I'd like to welcome you to today's program, The Future of Employment Discrimination Class Actions, a briefing on Wal-Mart v. Dukes. I'm Caroline Frederickson, the Executive Director of the American Constitution Society for Law and Policy. And for those of you who are not familiar with ACS, we are a network of lawyers, judges, policymakers, academics, and law students dedicated to restoring the vision of our Constitution as a protector of human dignity, individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. Wal-Mart versus Dukes, as many of you know, is one of the most anticipated cases before the Supreme Court this term, and oral arguments will be heard next Tuesday, the 29th of March. In the decades since this litigation started, many would argue that little progress has been made in eradicating workplace gender discrimination. And indeed, a recent report by the Department of Labor demonstrates that working women still earn significantly less than working men. Wal-Mart versus Dukes will have an impact on how future inequities based on sex discrimination will be remedied or not by the courts. As the Supreme Court sorts through the technical issues and narrow questions of class certification that are presented, we must understand what are the broader implications of this, the largest employment discrimination class action in U.S. history. Will class actions be an available response to workplace discrimination post-Wal-Mart? What will a decision in Wal-Mart mean for the future of all civil rights litigation? Is the Supreme Court, as some say, inclined to weigh corporate interests higher than those of our nation's workers? And can we look to recent court decisions for answers to these questions? Well, we are very fortunate today to be joined by a distinguished group of experts to examine these and other questions. And I have the very great pleasure of introducing today's moderator, Professor Selmy. Michael Selmy is Samuel Tyler Research Professor of Law at George Washington Law School. He teaches courses on employment law, employment discrimination, and constitutional law, and has been widely published on these and other subjects. Prior to entering academia, Michael litigated employment discrimination cases with the Lawyers Committee for Civil Rights under Law and with the Department of Justice's Civil Rights Division. Michael also served as a law clerk to Judge James R. Browning, who was then Chief Judge of the Ninth Circuit Court of Appeals. So please join me in welcoming Michael. Thank you very much for doing this today.
Thank you very much, and it's an honor to be here. And before we get started with the panel, I just want to give a quick summary explanation of the posture of the case, because it's slightly unusual in the way that this case is arising in the Supreme Court. So this claim was filed against Wal-Mart for sex discrimination nationwide in 2001 by a group of attorneys who formed the case around some claims, and the case was originally filed in California. And although the case has been pending for 10 years, not much has actually happened in it, and that's the one part that I wanted to just frame, because that's going to be a lot of the discussion by the panelists. So the case involves class-wide allegations of sex discrimination in pay and promotions by Wal-Mart. And a lot of the case involves statistical analysis, in part because the class is so large and because the statistical analysis is able to identify patterns across the company that would not necessarily be present or evident individually. And that's one of the aspects of the case as it proceeds. The question that is still being argued about is whether this case can be heard as a class action, whether it can be done collectively as opposed to individual cases. And that issue was originally decided by the district court in San Francisco in 2004. So we're 7 years out from that initial determination, and that's the issue that's still present. Twice, the district court in San Francisco held that under the federal rules of civil procedure, which govern the process. It's Rule 23 here, and there's different components of that are likely to be discussed. That the case could proceed as a class action. In fact, it was advantageous to proceed in a case like this, given the size and the common issues, as a class action. That decision was twice affirmed by the Ninth Circuit Court of Appeals over the ensuing 7 years, and once by a 3-judge panel. And then in the Ninth Circuit, they were also able to have a broader court, although not the full court, consider it. And then there were 11-judge panel that upheld that certification decision by a vote of 6-5. The Supreme Court is now addressing the issue of whether the Wal-Mart case is appropriate to be handled as a class action. Some of the issues in that question involve the nature of the allegations with respect to sex discrimination, but it's possible that as the case unfolds in the Supreme Court, they will only address the class action issue and not get involved with the sex discrimination component. But the panelists will discuss that more, and I just wanted to give you that framing. Now, probably the best or the most advantageous thing for the plaintiffs, given that the case is in the Supreme Court, is the Supreme Court actually moves quickly, so it won't be another 7 years. From start to finish, it'll be about 8 months, and we should have a decision by the end of June in that. So with that said, let me, I'm going to introduce the panelists as they come up rather than do them all now. And our first panelist is Marsha Greenberger, and I assume here she probably does not need any introduction, but she still deserves one. So I will give you a brief introduction for her. Marsha Greenberger is the co-president and founder of the National Women's Law Center, where she has been doing work on issues relating to gender equity for many years, and great work at that. She's a recognized expert in women in the law and has worked on a number of landmark litigation cases and also legislation, including the most recent legislation in this area, the Lilly Ledbetter Fair Pay Act. So please welcome Marsha Greenberger.
Thank you so much for that introduction. Thank you so much, ACS, for holding such an important session, because this is one of the most important cases involving whether or not discrimination laws will have, as a practical matter, the force and intent that they were intended to have when Congress passed them. It will depend on whether or not workers, employees, such as the women in Wal-Mart, can band together to be able to bring to light the full panoply of discrimination that is affecting, in this case, women with respect to pay and promotions at especially a large employer. And of course, Wal-Mart is the largest employer in this country. In the introduction, I was described that I had worked on the Lilly Ledbetter case, which is true, and then legislation, the Ledbetter Fair Pay Act, that was passed in response to a 5-4 Supreme Court decision just a few years ago, which also seemed to be on a technical issue. That was an equal pay case brought by one woman. And the technical question was whether or not she would be out of time in filing an equal pay case. In truth, when the court found 5-4 that she was out of time, it undermined the ability of employees generally to vindicate their rights in court. Here, too, are workers banding together to demonstrate a broad pattern of discrimination. And that is so essential. The bigger the employer, in many respects, the more important the class action vehicle is, both to elucidate the nature of the problem, to make it practically feasible to come up against an employer the size of Wal-Mart, and to be able to discover and determine all of the facts at issue. There are a few things about the facts at issue in this case that I want to underscore just in setting the stage as the discussion goes on. First of all, one thing that's quite common in this case was in place with respect to the Ledbetter case and many other workplaces. The employer has a policy that employees are not supposed to talk about their pay. Therefore, in Lily Ledbetter's case, she did not find out until decades after she had been working at Goodyear that in fact she was paid less than her male colleagues, and only found out from an anonymous note. Women in Walmart, men in Walmart, are not allowed to talk about their pay with each other or to ask about it from each other. So the pay practices are discretionary, which is a policy that Walmart set out, which allows managers a broad discretion to determine what the pay should be, shrouds those decisions in secrecy, does not set up standards, as the plaintiffs alleged, that would allow and ensure for the kind of consistency and fairness that would root out discrimination, but rather, as the experts described it, because of that kind of discretion, reinforces stereotypes, old boy networks. Secondly, a practice described at Walmart is a failure with respect to promotions to post jobs routinely that are available. Therefore, in many instances, as described by the plaintiffs, women did not ever know that there was a possibility for promotion to be able to apply for the job, and often only found out after a person was selected. And the statistics showed far more often a male employee than a female employee that the promotion was available to begin with. Under the evidence provided in the Wal-Mart case, women had higher work evaluations than men, lower pay, fewer promotions, and the further up the ladder they went, the fewer promotions they got. And also, they had to wait longer to get those promotions, even if they knew about them and got them. So it's a reinforcing web of lack of policies, lack of procedures that would encourage fairness, transparency, that works to the disadvantage in, as experts described, in a broad-based way all across the country at Walmart, but is also a set of employment practices that we find in many employers across the country and are best able to be uncovered and ultimately remedied through this class action kind of mechanism. Buttressed by the individual stories that the plaintiffs like Betty Dukes described of her situation, and there were about 120 sworn statements, declarations, filed by other women employees across the country at Walmart who described classic sexist comments about Janie Q's in the women employees. Women don't get the same pay as men because they're working just to work, but men are working to support their families. Women don't need as much pay as men. Women aren't as aggressive in applying for promotions. Of course, if they had known about them, that might have affected their aggressiveness. Meetings being held, let's put it that Hooters seemed, from some of the examples, to be some of the better places where some of these business meetings were sometimes held. So these specific examples buttress the statistical disparities in pay and promotion that the experts showed across the country at Wal-Mart. I'm going to stop my comments now, but go back with an observation that I made in the very beginning. And that is, through the most technical and dense-sounding legal issues, this court will ultimately decide whether employees in this country, women in this country, minorities, others, older workers, disabled workers, will be able to hold employers accountable, or whether it will be left to an individual to uphold and protect her rights against the biggest employer in this country and have to find the resources on her own to combat the kind of litigation that has taken now 10 years just to talk about these preliminary matters before you ever even were to get to the chance to carry the burden that plaintiffs have of proving that the discrimination that they are describing has actually taken place. Enormous resources. Wal-Mart is perfectly entitled to marshal them, to defend itself in court, but it's the class action mechanism that allows employees to be able to bring these issues to the fore and to allow justice to be served and ultimately fairness to be meted out. And in these economic times, if ever there was any time when women workers and the families that they support need that fairness and justice, it's in these times. Thank you.
Thank you very much. Our next speaker is Susette Malvo, who is an associate professor of law at the Columbus School of Law at Catholic University, where she teaches courses on the civil procedure and complex litigation and the employment discrimination. So we've got the combination there with respect to the civil procedure and the discrimination issues. Her law practice also included employment discrimination work and class action work. So we've got great expertise, and please welcome Susette Malvo.
Thank you so much for having me here. I'm going to address one of the issues that is squarely before the Supreme Court. It's a little technical, so bear with me, but it's very important. And the question here is whether or not the plaintiffs in Wal-Mart can seek monetary relief under this particular class action rule. And if they can, under what circumstances can they seek that monetary relief? And then let's step back and think about why is that important to employment discrimination cases. First of all, as was mentioned before, Rule 23 is what we're looking at. Rule 23b2 in particular is what governs. But it's appropriate if you have a defendant that acts in a way that's broadly applicable to most people in the class, then it's appropriate to have a class action. And they're seeking an injunction or maybe a declaration. So for example, if everybody is challenging the same general practice, the same sort of systemic conduct in the workplace, everybody pretty much shares the same goal. If we share that same goal, then we are sort of united, and it makes sense for us to come together as a class. And because of that, under this particular rule, the lawyers don't have to send notice, individual notice to every class member. They don't have to give everybody an opportunity to get out of the litigation. And we allow this because the class, by definition, is very cohesive. We're all employees. We're all challenging this particular policy that is in place. So maybe we want an injunction. We want the court to say, we want this discriminatory policy to end. Or we want a declaration. We want the court to say, hey, we're declaring that your conduct is illegal. So we're bound together and we're a cohesive class. Now, not surprisingly, this is exactly the type of class action that has been popular for civil rights cases. In fact, the drafters of this very rule told us that this is what we designed this rule in mind with class action, with civil rights cases in mind. It was designed for exactly the kind of case that we're looking at with the Wal-Mart case. We want an injunction to stop this policy. We think we want a declaration. We think it is illegal. Now, in addition to this injunctive and declaratory relief that the plaintiffs are looking for, they also ask for monetary relief, and certain types of monetary relief. That's important. They ask for back pay, and they ask for punitive damages. So basically what I mean, back pay, it's simply wages, salaries, any kind of monetary relief that you are entitled to that you were denied because of the discrimination. So, but for this discrimination, I would have been paid X, but I was paid Y. And that back pay is just meant to make somebody whole again, to put them back in the place that they would have been but for this discrimination. And we know often back pay is easily calculated. It's based on a formula. The employer has the data. We can calculate that without too many complications. Now, plaintiffs were also looking for punitive damages. And punitive damages are brought up in particularly serious cases, serious circumstances, where an employer may in fact have discriminated with malice or reckless indifference to the federally protected rights of its workers. And so here the idea of punitive damages is not so much how do we compensate individuals, but is focusing on the conduct of the employer. And the idea there is to punish the employer and deter future misconduct. So we know that the plaintiffs in Wal-Mart were looking for that too. And finally, there's something called compensatory damages. Now, the plaintiffs actually didn't pursue those damages, but that's important to know about. Compensatory damages, you compensate somebody because of emotional harm and distress that they've been through, mental anguish, sort of a loss of enjoyment of life, that sort of thing. And those weren't pursued here because those are more difficult in terms of having individualized hearings. You can't really bring that necessarily together. So the plaintiffs here sought monetary relief. And the question is any monetary relief permitted? Well, the answer is yes. Wal-Mart argues that this rule bans monetary relief, but that's not true. If we look at the rule is silent. The rule doesn't say that monetary relief is allowed, and it doesn't say that it's prohibited. So you can't import language into the rule if it's not there. How do we know monetary relief is available for the plaintiffs in Wal-Mart? Because the drafters of the rule told us so. They basically said the advisory committee in their notes indicated they had in mind monetary relief when plaintiffs were coming forward, as long as the monetary damages you're seeking are not going to be predominant. They're not going to take over the case and be more important than the injunctive or declaratory relief. And in fact, all of the courts of appeals to have looked at this issue have agreed, have come to the same conclusion. So this is well-settled law. The only issue that's really open is whether or not, if you're seeking monetary damages, do those monetary damages have to predominate? Now, I want to say something about back pay, because back pay has historically been allowed in Title VII cases. Title VII of the Civil Rights Act of 1964, and that's what plaintiffs were looking for. Back pay is considered equitable relief. It's related to that injunctive and declaratory relief. And because of that, courts for decades have allowed back pay. It's a critical component to Title VII's remedial scheme and to enforcement of the employment discrimination laws. And we know that back pay is critical to eradicating systemic discrimination, to making people whole, and to deterring future misconduct by employers. And so and in fact, back pay is so important. The Supreme Court has said there's a presumption in its favor. So we know that back pay is important to the enforcement of civil rights, and we know that monetary damages are dealt with a little bit differently. The courts there, they allow monetary damages, like compensatory damages and punitive damages. But those damages, you do have to be careful that they don't predominate, that they don't take over the litigation, because the courts have recognized there is a little bit of a risk there that the class members may not share the same interest. I talked about compensatory damages. You might not be able to plug into a formula. Everybody sort of takes that discrimination in different ways. And so you have to figure out whether or not that relief predominates. So really the question that's before the court now is, how do you measure predominance? How do you figure that out? It turns out that the courts of appeals are divided in 3 ways. They've come up with 3 different tests, and so the Supreme Court is going to have to figure out, how do I resolve that 3-way circuit split among the courts? And if I can conclude with telling you, why does this matter, really? Why do we care here in terms of if the plaintiffs lose, if you can't have a class action? This is very important because plaintiffs, it may become more difficult for them to proceed collectively as a class action. And for many people, employees, consumers, and so forth, this is the only access they have, meaningful access to the court system. So we want to be careful to protect the class action device and make sure that people continue to get back pay, to eradicate systemic discrimination, to make people whole, and to deter future misconduct.
All right, our next speaker is Andrew Trask, who is counsel at McGuire Woods, where his practice focuses on class action defense. So we'll have a bit of a different perspective here. And Adam is the co-author of the Class Action Playbook and maintains the Class Action Countermeasures blog, which discusses strategic considerations involving class action defense. So please welcome Andrew Trask.
Hello, can everybody hear me? I know adjusting the mic is sometimes an issue, so I got asked beforehand as I was sitting eating my lunch whether or not I was the token right-winger on the panel. And I hate to disappoint you all, but my mother had me handing out Michael Dukakis for governor buttons when I was much smaller. That hasn't really changed, actually. So, you know, I'm not up here really to espouse a right-wing view. I think I also probably would get asked, am I up here to defend Wal-Mart? And my answer, again, is going to be no. I mean, here's the thing, right? Wal-Mart is is the country's largest employer. It has 1 million employees. It has a market capitalization of $174 billion, that's with a B, dollars. It has assets of $170 billion, that's with a B again, dollars. And it had sales last year of $384 billion with a B, dollars. Walmart can take care of itself. So who am I up here talking about then? I'm going to talk to you actually about all of the people who are not in the caption of the case, and those are the absent class members, as they're frequently referred to. And one of the reasons why Rule 23 is so important is it allows people like Betty Dukes, and keep in mind, I mean, this is a David versus Goliath matchup, right? I just described Walmart. Betty Dukes is a greeter at Walmart. Her job is to stand on her feet all day wearing a blue vest and make people feel welcome to her store. You know, she's one of 63 named plaintiffs, and those are people who actually have put their stories out there. There are behind them 1.6 million other women, and the issue here is whether or not Betty Dukes and her 62 fellow named plaintiffs can adequately represent all of those other people. If you rule for Betty Dukes, can you take that verdict and hand it over to these other 1.6 million women and still have their cases be proved? That's what Rule 23 at its heart is about. It's why it's so powerful when it's well used, and it's why it's so important that it be used carefully. So the 2 things I want to talk about today are 2 of the really difficult issues the court is going to have to face. And they both have to do with whether or not Rule 23 was used carefully in this case. I don't think anyone here is going to argue that Walmart probably has no gender discrimination. They've got 1.6 million female employees over time. You know, there's going to have been some discrimination there. So it's not, is Walmart blameless? It's, is this the right way to try the case? And that's what the justices will really be focusing on with Rule 23. So let's focus in on the 2 most technical and at the same time important issues that are going to come up. One of them, Professor Malvo, did a great job of describing to you, and that is, which bucket do you put this case in when you look at the second part of the rule? There are 2 parts of Rule 23. There's 23A, that everybody has to meet, and there's 23B, where depending on the type of case you're bringing, you have to prove slightly different things. So let's start with the end part. Let's start with Rule 23B. There are 3 buckets in 23B. Your first bucket we don't have to care about here. Nobody has brought it up, but let's call it the zero-sum zero-sum game bucket. It exists when you have a case where any one class member's verdict would actually deprive everybody else of getting their fair share of whatever is in dispute. You can think of it like bankruptcy, although that's not exactly what it is. The second bucket, the 23B2 bucket, in the rule itself says it's for injunctive and declaratory relief. Now, it doesn't say no money, but it doesn't say money either. It just says injunctive and declaratory relief, and that's the label on that bucket. The third bucket is traditionally used for money damages and anything else. And with the third bucket, you have to jump through a couple of extra hurdles. You have to demonstrate that common issues predominate, and you have to demonstrate that the class action is better than any other way of resolving the dispute. We call that superiority. And the reason you have to do that is because when money claims are at issue, people suddenly care a lot more than if it's just an injunction. Not that injunctions aren't important, but an injunction is going to go up no matter what, and people are going to be affected no matter what. And so it doesn't make sense to ask people whether or not they want to opt out of changing a company's behavior. The behavior will change no matter what. With monetary relief, you release your claims in exchange for some money. And if you're going to make that trade, if you're going to trade your claims for money, then you need to have proper notice. And the notice requirements are different between 23B2, that injunctive bucket, and 23B3. So the real question here is, what's this case really about? Is it about getting the injunction against Wal-Mart, or is it about getting the monetary relief, no matter what you call it? And frankly, in this case, one of the things the court's going to have to wrestle with is the following fact. There are 1.6 million women in the certified class in the lower court. 800,000 of them, that's half, are no longer employees with Wal-Mart. Changing Wal-Mart's behavior does nothing for them at this point. They're only in it at this point for the money. The other 800,000 are in it for both the injunction and the money. And so the question becomes, when really the only relief uniting the entire class is the monetary relief, should you really have put them in the injunctive bucket? That's the first question. As you can tell from the way I've framed that question, I disagree with Professor Malvo. I think that even though you can have back pay, in this case, it's the money that's driving the case. It's not the injunctive relief at this point. And that matters. And why does that matter? Because these 800,000 people who are out there who aren't going to benefit from the injunction really, really care about whether or not they get heard in the case. And the only way they're going to get the notice and the opportunity to opt out if their claim is particularly strong is if it's put in the money bucket as opposed to the injunctive bucket. You see, in the money bucket, you can opt out of the class if you have a very strong case, if your case is stronger than Betty Dukes's. In the injunctive bucket, you can't. And that's a really, really important thing going forward for women who may have suffered greater discrimination than Betty Dukes did. The other issue that I want to address very quickly is the other thing that the court is addressing primarily, and that's the issue of what's called commonality. That's in that Rule 23A section. There are 4 things everybody has to demonstrate if they want to have a class certified. Numerosity. We have 1.6 million women here. It's not an issue. Nobody's arguing this one. Commonality is the second one, and the question is, if you have an issue that's common to everyone, is that enough? Ordinarily, commonality is a low bar to meet, but it's not so low that it doesn't exist. I mean, we could define people in such a way that no matter how we define them, they've all got a common issue. We could simply ask, did Wal-Mart treat all of these people like human beings? It's a common question. But the problem is the answer to that question isn't going to take you very far in the litigation. In order to prove discrimination from that point forward, you're still going to have to prove how it was that Wal-Mart treated you inhumanely. In this case, we're not too far away from that level of generality, though, with the way the question's been defined. The question as it's been defined, and I'm going to use some of the language that's actually been used by the plaintiff's expert in this case, is whether or not Wal-Mart fostered a, quote, corporate culture that allows for, quote, gender stereotyping, and a corporate practice of giving store managers excessive subjectivity in multiple types of personnel decisions. When you ask the question like that, it's pretty easy to say that it's common to everyone here, but the answer isn't going to make a lot of difference to many of these women. In order to prove that they themselves were discriminated against, they're still going to have to bring forward most of their claim. And that means that you've held a huge trial for very, very little progress at all. Now, that's not to say that you couldn't certify a class against Wal-Mart. Very briefly, Wal-Mart has 41 different retail divisions, all of which are staffed by their own vice president who makes policy. You could break down a class action into 41 of these. Right now, I think the damages have been put at roughly $1 billion for the full class. A 41st of $1 billion, still enough money to make a lot of lawyers salivate. So it's still enough to allow for a class to go forward. But this class, the way it was certified, may have been too big and too diverse. And that's one of the things that the Supreme Court is going to be wrestling with. Thanks very much.
whenever I participate in a panel like this, I always hope there's no law students in the audience, because in terms of the intricacies of Rule 23, we would torture them for days, if not weeks. And we just had, in 14 minutes, clear, concise, and actually complete analysis of the issue. And we have a bit additional work with Adam Klein on the related issues. Adam Klein is a partner out in Golden and is the chair of the firm's class action practice group. His practice is limited to the prosecution of class actions and the impact of litigation and employment discrimination, and he's testified in Congress and been involved in employment discrimination class actions for a number of years, and he's going to provide analysis on some of the related issues with respect to the class actions. Please welcome Adam Klein.
Of course, the problem with going last is that everyone took the good jokes, so I'm left with bad ones. One of the issues that's presented in what you've heard is, to what extent does the court consider the issues of Rule 23 class certification as a question of abstract concepts versus the merits of the case versus what the practical effects of a decision are? So just to make the point, and it's been made before, but I'll make it again, this is a case involving low-wage workers, women, who are the victims of discrimination. That's the theory of the case. The question is, can they prosecute the case in an economically rational way? It's a tale of two cities, or perhaps a Bush v. Gore construct, in that, on the one hand, you have the impossible result of any number or few number of women who could conceivably find a lawyer and prosecute their individual cases and not be able to do one thing about the systemic problems that they've encountered at Wal-Mart. On the other hand, you have this gigantic potential exposure that the defense bar will complain about bitterly and say, this is about lawyers trying to get money, and it's lawyer-driven, and that's sort of the extreme descriptions of the same case. And in that construct, what does the Supreme Court do? What is the issue before the court? Well, first, it's not on the merits. I think that's a very critical point. This is not a decision that will relate to the merits. So whether the plaintiffs are right or wrong is irrelevant to the questions that will be decided. What is at issue is whether the elements of Rule 23 have been satisfied, and in particular, whether there's a right to proceed under Rule 23b2, which was discussed. There, the question is, what are the plaintiffs actually seeking to obtain? Well, what the plaintiffs will tell you, and I know them, the lawyers very well, what they'll tell you is they're trying to change the company practices that are harming their clients. That's the primary objective of the litigation. The fact that there is an economic value to that is secondary to the primary objective of changing the company so they can eradicate discriminatory practices within the company. That is the objective of the litigation. One of the examples or further points in support of that is that they've waived the right to compensatory damages. So no one, including the named plaintiffs, will be entitled to any compensatory damages. They're limited to back wage damages and potentially punitive damages. Now, a note about punitive damages. What this comes down to is, are punitive damages, are compensatory damages, is the aggregate value of back pay superior to their interest in seeking injunctive relief? That's the discussion that will be held before the Supreme Court. And what's interesting is that if the plaintiffs say to the court, our objective is equitable and injunctive relief to eradicate discrimination within Wal-Mart. In fact, that is the primary objective. That objective can be satisfied. And just to make the point, in the Ninth Circuit, the court certified the equitable and injunctive relief class. Now, I don't mean to get too technical, but the Ninth Circuit certified the primary objective in the litigation under Rule 23b2 for equitable and injunctive relief. There was no request for compensatory damages. That's gone. The right to proceed to obtain punitive damages was remanded to the court, and the question then is, can that be certified? Well, wait a minute. How do you certify equitable and injunctive relief but not certify a right to punitive damages? If you don't have a certified punitive damages claim, that's not worth anything. It would be worth some amount of money for individual victims that come forward, but in the aggregate, on behalf of the class, this hydraulic pressure that's complained about doesn't exist. So what the Ninth Circuit did was they tried to address the defendant's primary argument against certification, that you have this annihilatory exposure in the construct of punitive damages and to some extent on back pay damages, the Ninth Circuit said, well, we can fix that. We can simply certify the class under B2 for equitable injunctive relief. We'll put off the request for punitive damages to a different day. Maybe you get that certified, maybe you don't. Not important at this stage in the case. The question I was asked to comment about was common issues and sort of what the case is about in terms of supporting commonality. Rule 23, that's a very important concept. And here you have a question of whether the practices that the plaintiffs articulate, the subjectivity, the stereotyping, whether there's a causal link between those observed phenomena and disparities in compensation and promotion decisions. Can you draw a line? Is there enough of a nexus between stereotyping, between subjective decision-making, and the observed disparities in terms of compensation and promotion? That's the question. The courts call it bridging the gap. Bridging the gap in terms of the individual experiences of the named plaintiffs and those of women who came forward in support of classification, and whether that information, those experiences, can be generalized to the class in support of class certification under the commonality prong. That's the essential question in the case. When you put aside this other point about sort of annihilatory damages or effects of punitive damages and the aggregation of economic loss claims. So that's the issue that the court will really tackle at the argument. It'll be very interesting to see that it plays out. One other point, just as a counterpoint to Andrew, money driving the case. It's really a function, it's sort of an obvious point, it's sort of a function of the size of the case and the size of the company. So again, this is a tale of two cities point. You have individual class members who earn relatively modest amounts of money, $7 to $10 to $12 an hour. Their individual claims have very modest value. At the individual level, you aggregate them, it's worth a lot of money. That's simply merely a function of the size of the company, and I don't think that in and of itself is going to be a fact that the court will rely on or consider it to be determinative. So, and one other small point, injunctive relief versus injury in fact. So the question is, well, what happens if there's a finding, a grant of classification, a finding of liability? Do individual absent class members get a check? Perhaps, perhaps not. The reality is each individual class member may or may not have an injury in fact, may or may not be entitled to an actual check to compensate them for a potential claim of discrimination. Again, going back to the point, the main point of the litigation is to eradicate systemic discrimination within Wal-Mart, to fix the practices that are causing harm. The secondary question is, will any individual absent class member be entitled to a check at the end of the day? That's to be determined and not before the court right now. Thank you.
Thank you very much. I want to thank all the panelists for excellent presentations and also for staying on time, which I'm going to also try to do by, my role now is to ask a couple questions of the panel. I think I'm going to keep it to just 2 questions, and then we'll open it up to questions from you all. And the first question I'm going to direct to Marsha Greenberger, but everybody is free to chime in on it. And this has to do with the commonality that we were just, Adam Klein was just talking about. But if you could say a little bit more about the common allegation of sex discrimination through the company and why that's appropriate for class treatment as opposed to doing individual cases, what those allegations are.
Well, again, what's at issue in the Wal-Mart case is so important because the nature of the discrimination that is being complained of is something that is replicated in many companies across the country. What Wal-Mart is basically arguing is, first of all, that given the nature of this issue of commonality, there shouldn't be a class action at all. And so I do want to get to your specific question, but that is what it's really going down to. Versus the second issue of, well, should it be this B2 class that covers everybody or a B3 class where people can opt out? But the Supreme Court specifically, its first question is a class action allowed at all? And that does get to this commonality point. Well, what the nut of it basically is Walmart's nationwide policy that managers all across the country can decide what they're going to pay their employees and how they're going to promote their employees based on their own discretion with virtually no real guidance, no kinds of standards that would support non-discriminatory and fair decision-making. It's contrasted in the Wal-Mart case to quite specific policies about temperature, for example. Managers were told they have to keep the stores at a specific temperature. They're not told, find a comfortable temperature that seems to work for you, and then set the thermometer in your store to fit what you think is right. But when it comes to pay and promotion policies, even whether you have to post the job openings, Walmart says, up to you, you do it how you want to do it. That nationwide conscious decision on Walmart's part to leave such extraordinary discretion to its individual managers is what, at the nub of the case, is the policy being complained of that affects the whole nationwide class of women. When that kind of discretion operates in a way that leads to fairness, employers can continue to follow that kind of policy. But as the experts say, that is not usually the case in today's society and today's world. And that's where all of these sworn declarations and the individual stories of the named plaintiffs become so critical. They are describing common discriminatory practices all over the country of discounting why women are working to begin with, of discounting their commitment to the job, of assuming that they shouldn't be paid the same as men, that they will not be as good managers as men, and being allowed to use those biases unchecked in the way that they make decisions. And that is the common policy that Walmart has adopted to allow those kinds of biases to operate, and what the plaintiffs are seeking the opportunity to then establish in court as something that truly exists across the country affecting all of these women. So I do want to underscore, it's up to the plaintiffs to prove all this. But what's so critical is that they be allowed to shoulder that burden on behalf of all of the employees who are affected by this headquarters policy that it is up to all the managers for all of these employees to decide how they are going to make decisions on whatever grounds they choose. This morning, I happened to do a call-in radio show, and the Wal-Mart case came up quite a bit in the context of women in the workplace now, the fact that still nationwide women are only earning about 77 cents on every dollar for men, and in the retail section of our country, the wage gap is even worse. It's in the 60-cent range, 64 cents, I believe it is. So, and Walmart, according to the evidence, is actually even worse in its statistics than its largest competitors in the retail area itself. So the common thread here is this kind of go do it your way coupled with the underlying discrimination and stereotyping that plaintiffs have alleged, have demonstrated to some degree, but would have to prove, the common practice that has to change in Walmart. And that is the nub of what's at issue. And in the call-in show, a number of male managers at Walmart called in. And I'm thinking, uh-oh, are they going to say, oh, no, it was fair? That is not what happened. They said that actually it was, and is the case with at Walmart, women got higher evaluations for the quality of their work, even though they weren't getting the same pay and they weren't getting the same promotion rates. And at least with respect to these male managers who were calling in, they were reaffirming the kind of whatever your reasons, if you see this as an old boys club, if you want to promote your pals, that was okay, and that they saw a lot of unfairness against very hardworking women at Walmart. It's that discretion that is allowed when there is also, as alleged by the plaintiff, so much stereotyping and discrimination that is the common practice that is the heart of the case here.
Thank you for providing a little bit more background to the allegations there. And so I want to ask one more question. You may not be surprised to hear this. I'm going to direct it to you, Andrew, and ask you a question in terms of the class certification issues. And I think you presented a strong and argument for some of the difficulties in the case. But it also seems to me that those are arguments that apply to employment discrimination cases generally, as opposed to just the Wal-Mart case. And so one of the issues that I think is present in this case is whether, if the Supreme Court holds that the Wal-Mart case is not appropriate for class certification, whether that would also mean that there cannot be any more employment discrimination class actions, and what the possible rationale for that would be, given that there's nothing in the rule that suggests they should be treated differently. And, as Professor Malvo noted, the class action entity grew up around civil rights class actions, employment discrimination class actions, much like this one. And so if you could just address that issue, whether about the ability to certify class actions generally.
Sure, and that's a great question. And my first answer to it is, I think the employment discrimination class action will survive Wal-Mart v. Dukes regardless of what the court rules. Here's the thing about class actions in general. They're a remarkably versatile device. They get used in environmental cases, antitrust cases, employment discrimination cases, products liability cases, and that's all with that one Rule 23, just as I described it to you up there. So Rule 23 can be modified to serve a lot of different subject areas in the law. And here's the one really important thing that Professor Selmy just brought up that's also really important. Rule 23 was brought about, really a lot of it arose out of a series of desegregation cases back in the 1960s. And as Professor Malvo described, the 1966 Advisory Committee, which are basically the people who helped to draft the rule, were incredibly impressed at how effective the class action was at effecting desegregation over time. You know, it was a remarkably useful device for that, particularly where injunctive relief, these court orders to force desegregation were involved. So it's got a long and storied civil rights history, and I don't think anyone on the court is unaware of that or wants to spit in the face of that history. I don't think that's part of the issue here at all. What's really at issue here is the way that the Wal-Mart class action has been set up. If you allow it to be certified the way it is it an effective tool for aggregate relief for the class members? And that's the question in any given class action. And I think the Supreme Court has before it the opportunity to clarify a few open questions in a couple of different areas that would not in any way destroy the employment discrimination class action. Would they be harder to bring than if they affirm Wal-Mart versus Dukes? Of course. If the Supreme Court affirms Wal-Mart versus Dukes, you're going to have it comparatively easy in the employment discrimination field. And that's not necessarily a bad thing. That's a policy question as to how easy you want to make it. But here's what happens, I think, if they wind up basically ruling in Wal-Mart's favor. First, on this 23B2 issue, the real question will become, can you bring these very large monetary damages awards call them back pay, and then certify them in the injunctive relief bucket. And if the Supreme Court says no to that, that doesn't mean that Wal-Mart, will be immune from class actions going forward. It means it will likely face a lot more class actions in the B3 bucket, where when people are bringing class actions seeking monetary damages, they'll just have to prove that common issues predominate, and they'll also have to prove that the class action is a superior way of bringing the case than any other way. There have been class actions certified under Rule 23b3. It's not terribly hard to do. As far as the commonality question, I don't think the Supreme Court's going to be ruling one way or the other that commonality is a specific bar to hold to. What it's going to be doing really is asking whether on the facts of this case, commonality got met. And here are a couple of reasons why the Supreme Court could rule in this case that commonality was not met without necessarily undermining what we've already talked about as some of the real nubs of this issue. Basically, they'd be allowing the plaintiffs to sharpen the case a little. Here's what they're currently facing with this class. We have a class that spans 13 years, during which policies probably changed. 3,400 stores, which is, as we've heard, have managers who are given close to unfettered discretion in how they make decisions. 53 departments per store. 170 different classifications of jobs within Wal-Mart itself, from Betty Dukes, the greeter, all the way up to M. Susan Chambers, the executive vice president in charge of global personnel. Within that, there are going to be a number of different issues that probably arise. And the Supreme Court will be able to say, I think, that there isn't really a common question among all of these women, where if you broke it down into what are commonly referred to as subclasses, smaller groups within the much larger group, you could find uniting common issues. If you break it down by, like as I mentioned up there, there are 41 retail regions. Let's assume that the executive vice president in charge of each retail region, and they each do have their own VP, set some policy. Then you've got a common question. Was the policy that executive vice president set discriminatory? That's a case that you can still bring. And I think that's still an economically viable case to bring. So what it really comes down to on that end is whether or not the Supreme Court will rule that you can have something this broad, or whether a narrower class would have been more appropriate. And narrower classes don't mean class actions don't exist. They may mean that they're slightly less profitable to bring, but you're still going to have plenty of economic incentive there to do it. The final issue that none of us have talked about yet that I think the Supreme Court is going to wrestle with as well, and I want to bring it up very briefly, is that and I'm sure you're all familiar with this in litigation in general, there's no such thing as an independent expert in litigation. Each side hires their own experts to make their points. And so as we sit here and we talk about what the experts say, for the most part, we're talking about the experts on whichever side we happen to represent, and what we've paid them to say. And those experts tend to disagree in this case. We have statistical experts for the plaintiffs who say that it's very easy to show you common effects among even this broadly defined class. Wal-Mart's got experts of its own, and they're saying something very different. And one of the things that's come up in front of the Ninth Circuit that it had to decide, and that's likely to be an issue the Supreme Court has to decide, is how much do you have to decide which expert is right before you certify a class? Can you just punt and say, well, the experts disagree, so we'll put it to the jury? Or do you have to say at this stage, when we dive into the experts' methods, one side's reliable, one side doesn't seem to be, and that's going to help influence our decision. The various appellate courts have split on that question, and that's one of the things that actually has been briefed in front of the Supreme Court. It's a fairly technical issue, but I actually think it's going to be one of the more important issues the court decides. So short answer, employment discrimination class actions will still exist.
All right, thank you. Does anybody else? Go ahead, Susette.
Yeah, just a couple of sort of comments in reaction. You had mentioned this notion of back pay, and that the plaintiffs here, if you call them, damages, that somehow you can squeeze your way into the Rule 23 B3 class. I mean, I think there's a real distinction between the type of monetary relief that you're seeking. There are back pay, there's compensatory damages, there are punitive damages, and so back pay is treated very differently than damages, and it isn't as if you can kind of conflate those terms and call back pay damages, or that there's some kind of ruse going on where the plaintiffs are calling back pay damages. Those are treated very differently. They have a very different history in terms of the court's acceptance of them under the B2 class, so we want to be careful not to conflate those terms. I think that can be confusing. Rather than sort of clarifying for people the difference between those and why that difference matters. The other thing I would add about the B3 certification, you mentioned that this was not that difficult to do. I would sort of beg to differ. I think getting a case certified under whether it's Rule 23b2 or B3 makes a big difference. It's difficult. It is more difficult to get a case certified under this B3 bucket. That requires that you show that common questions predominate over individual ones. You have to show the class action is the most superior mechanism of resolving the dispute. It requires that you pay, you have to put out individualized notice to class members. That can be extremely expensive, and that can bar plaintiffs' counsel from being able, in fact, to bring a class action at all, because can be a very exorbitant cost, and you might not be able to pursue your claim as a class action. So I think there's a little bit of I think sort of cold comfort in the notion that, well, don't worry, if you don't get certified under this B2 bucket, you still got the B3 bucket. There's some real disadvantages to that. In fact, those disadvantages may be so severe that you find people not able to bring meritorious civil rights cases at all.
Sorry, I don't know if this is on. Just as a follow-up, one thing that hasn't been discussed is, so what has the Supreme Court done in class action employment discrimination cases? Actually, the track record's pretty good, and I'll explain what I mean by that. There have been two recent Supreme Court decisions, one Ricci v. New Haven, the other Lewis v. City of Chicago, that both relate to disparate impact. And so the distinction here is critical. There's an intentional discrimination claim and a claim that doesn't require evidence of intent. And I think what's critical here, and if I were, so one of the questions that was presented to the panelists is, can you predict what's going to happen? So here's the route to success for the plaintiffs. The route to success, this is my thinking on it, is that if you look at their claims, they have both a disparate impact and disparate treatment claim. The disparate impact claim is that there's a facially neutral policy or practice, setting pay and promotion using subjective decision-making. There's some oversight, they claim, but that's the selection criteria that is being challenged. And the question becomes, is there a prima facie violation of Title VII? Well, what would be the evidence of that? A statistically significant shortfall in pay and promotion. That's not terribly challenging. The court will not be concerned with how probative, how persuasive the shortfalls are. Just simply, is there a prima facie violation of Title VII by way of a statistical shortfall? If that's true, if plaintiffs can make out that claim, then they win on the merits, unless the defendant shows that the practice is both job-related and consistent with business necessity. Now, that's going to be very challenging for Wal-Mart. The business necessity defense, their argument would have to be that our delegation of authority to individual managers in terms of setting pay and promotions is appropriate, is a required business practice. Well, we all know that simply isn't true. It's just illogical. But putting that aside, putting the merits aside, that all sounds like common issues of law or fact, doesn't it? That's a prototypical class action in the realm that we've already seen the Supreme Court approve in cases like Lewis v. City of Chicago, which was 9-0, by the way. So if the focus, so the question is, what happens to the case? Well, what happens to the case is that you get largely the same result. You get equitable and injunctive relief. You get a finding of liability. You get a back pay award for aggrieved class members. No availability of compensatory damages. They already waived it. No right to punitive damages. Well, the Ninth Circuit didn't certify the punitive damages claim, so they lose that. It's not there anyway. Not terribly consequential. So in my view, perhaps the secret hidden weapon, to use it in that construct, is to really focus on attacking the policies and practices under disparate impact theory and make the point that subjective decision-making in terms of setting pay and promotion is a facially neutral policy or practice. It's in the form of a selection criteria that can be challenged under Title VII. I think that's a true statement. And if that's true, then that should be certifiable.
Oh, thank you. And just so that Andrew doesn't feel like the only contrarian up here, let me just say briefly that I think it'd be a mistake to treat this case as one not involving intentional discrimination or disparate impact. And I think, although it's present in the case, that is kind of a ruse, to use the term that Professor Malvo used. This is a case about intentional discrimination. The allegations are all that Wal-Mart intentionally discriminates. It's not by accident, which is really what the disparate impact is. It might strategically make sense to frame this as a disparate impact case, but I think they would run into trouble very quickly thereafter. But since I'm the moderator, I get the last word on that. And let's now open it up for questions. With the questions, please identify yourself, and I understand that microphones will come to you as well. Go ahead. We're here in the first row.
Mark Greenberger, Press Associates News Service. An earlier ACS panel this year mentioned that the one exception to the general view of the Roberts Court is that when it came to workers suing about discrimination, the court has come down on their side. And the latest decision, third of three, was just Tuesday. Talk about both that and the other case they decided Tuesday, which was certifying a class action case where a company lied, and in terms of what predictive effect, if any, those two decisions could be on the Wal-Mart case.
I think that I would probably narrow their record in having decided in favor of plaintiffs in employment discrimination cases a bit more than you described. I think that where they have been willing to allow cases to go forward in particular is where retaliation is at stake, where someone has tried to vindicate their rights or get the anti-discrimination law enforced, and for the trying, they have been fired, they have been, their pay has been demoted, or they've been retaliated against in other ways. While retaliation can have some class impact, it is by and large a person-by-person manifestation of an employer's hostility to discrimination protections. And in that person-by-person context, I think the court has been willing to recognize that the very integrity of the civil rights laws would be undermined entirely if retaliation were allowed to go forward. I think that when we go much past that, we don't see as much of the concern for what is at risk and at stake, even in an individual case. And I think the Lilly Ledbetter case was a reflection of that, where it was a paid discrimination case. And in that instance, it came up with this one woman, wasn't a class action, but the implications were very broad for people being able to bring paid discrimination cases over time. I want to go back to make two very quick points. First of all, that much of what seems to take you aback when you hear about Wal-Mart, about how many women, how much money, how many regions, is by how big Wal-Mart itself is. So one of the things we really, not because the legal issues that are being raised in the case are that different from employers of all different sizes, but just because they get magnified when you are as big as Wal-Mart is. So one of the big concerns is if the Supreme Court lets Wal-Mart out of the class action responsibility to be held accountable based on the claims, then are we in our you're too big to be held accountable world? Or are we in a situation where the principles that will be applied to Wal-Mart then get applied and magnified to employers of all different sorts, of all different sizes? And that is, I think, at the end of the day, one of the greatest concerns with respect to Wal-Mart. And the second thing I want to say very quickly is, as we're talking about the back pay, when you have so many women employed, even though there are relatively small claims per woman, it adds up to a very staggering sum given Wal-Mart's size. As Andrew said, we don't have to worry too much about Walmart because it has an awfully deep pocket, and that the amount at stake, even though it seems staggering to the likes of me, is actually not very much money in the greater scheme of things for Walmart. The other major thing at issue in this case is, will there ever be an incentive for employers to clean up their act before they are sued? To believe that they could be held responsible in a big lawsuit for the unequal pay that they have been benefiting from all these years, because that is, at the end of the day, what pay discrimination means. If the plaintiffs can prove their case, Walmart has been pocketing salary that they should have been paying to all these women all these years. Or should it simply be they should sit back, and if a few women ever can get it together to sue them in some region, somewhere, in some store, on some narrow issue, sometime, they'll pay up in the future then. But in the meantime, it's way more economically sensible to just keep saving that salary that, if plaintiffs can prove, should have been paid, that they really denied the women and the women's families all those years.
I'd just like to hop in for a moment. I think Ms. Greenberger actually has really well addressed one half of the question that got asked, and the other half, very briefly. The Supreme Court decision from 2 days ago that involved a securities fraud class action was not a certification decision. It was actually done at the motion to dismiss stage. Securities class actions have a slightly different set of rules, so it's not going to have much of an effect going forward. And that just is because you had asked about both of them.
Thank you.
Yes.
Paula Brantner of Workplace Fairness. My question is addressed to Adam. As you said, the merits are not before the Supreme Court in this case, but we all know that the battle is typically over class certification, and this battle, in this case, has been going on for over 10 years. If the court certifies the class in the way that the plaintiffs are requesting, what happens now? Does a company with a history of aggressive litigation like Wal-Mart spend the next 10 years fighting the merits? Or does the fact that it's just back wages and injunctive relief mean that they start hashing out formulas to figure out all of these issues and look to settle the case relatively soon?
It's an excellent question. It's hard to answer. The history, if it's a guide at all, suggests that they'll continue to fight. I mean, I think this is a company, for whatever reason, feels strongly that they have a defense to the case, and that they're basically fighting a fight not just for their own benefit, but for other corporate employers as well. Why they think to take that on, I'm not sure, but I think that's an explanation, from my vantage point anyway. Not that I'm privy to any inside information, but my sense is that they've done a lot taken a lot of efforts, both strategically and tactically, to undermine this case at the class certification stage and on the merits. It's interesting too how litigation works out sometimes. The case that was certified was actually not the class that was presented by the plaintiffs. They wanted to include former employees as part of the class. They wanted the promotion claims to be certified, and they weren't. So there are issues that the plaintiffs have already lost during litigation as well. And the other reality is that there is such a substantial amount of money at stake that my sense is that they're going to be very concerned about that exposure, and will think to continue to fight as a negotiating tactic as well.
Well, let's see here. Or, go ahead.
I'm Heidi Hartman, Institute for Women's Policy Research. We did file an amicus brief in the case. I am a labor economist, so now I'm a little confused between what Andrew and Adam just said. But in your presentation, Andrew, you were implying that the class is 1.8 million or 1.6 million, and half of them no longer work at Wal-Mart, and therefore they're only in it for the money. And I took that to be a somewhat delegitimizing type of comment. Therefore, this class is, there's kind of a bunch of grubby women in it for the money. So I would like to suggest that the people who are past employees and no longer at Walmart, given how big an employer Walmart is, they have, and where they're located, which is often in rural areas where they have a monopoly position, they've already driven out all the other small retail businesses, given that women who are low paid and in retail tend to have high turnover rates, and given that Walmart is the big employer, they're very likely have already over the course of 10 or 15 years worked at Walmart many times. So they are likely to be interested in the injunctive relief because should they work at Walmart again, which most of them probably have already done, they want promotion and they want good policies there. So I wouldn't dismiss the half of the case that supposedly has no interest in the injunctive relief. Given where Walmart is located, they very much have an interest in that injunctive relief.
Just to answer that very briefly, this is a typical sort of abstractionism problem that courts engage sometimes, where they want to consider the hypothetical interests of the hypothetical former Walmart employee. Well, they can't interview the person or the group or whoever, and so they have to kind of guess what their interests are. And I think what Heidi just said is exactly right, that they do have a continuing interest to see that discrimination is eradicated at Walmart and within corporate America. I think that's sort of the social policy point that has to be made, and not this sort of abstract view of what a hypothetical absent class member would think.
In the
Do you wanna
second
get
round, well, go. Oh,
That's right.
go ahead quickly.
I mean,
we're just running.
Yeah, two very brief points, since it was addressed, I think, primarily to me. The first of which is, I apologize if it sounded delegitimizing. It was certainly not my intent to say these grubby women who are only in it for their nickels and dimes. My point was simply we got two buckets for class actions, and one is for injunctive relief and one is for money relief, and that often includes back pay, which can sometimes also be called compensatory damages. And given that these women don't have standing currently to seek injunctive relief, the only relief available to them in this case right now is the monetary relief. And at that point, when half of your class really is only in this particular case because of the monetary relief, that's going to affect which way I think the predominance analysis goes as to whether it's primarily injunctive or primarily monetary. I would think that any human being who wants corporations not to be discriminatory would have an interest in the injunctive relief, but the law only recognizes the ones who got standing before the court, and in this case, those are only the current employees of Walmart.
Of course, that's also a function of the passage of time.
It is.
In the second row here, go ahead.
Thank you. Steve Williams from NBC News. Professor Malvo, can I ask you, you talked a little bit about how the court will look at fairness to the class members. Do they get adequate notice? Do they have a chance to opt out? Does the court also look at the certification stage of fairness to the defendant, about whether it's just impossible to defend against a class that gets too big?
Absolutely. The court is going to look at fairness to everybody, including the defendant. And I think one of the things when we talk about class actions, sometimes we talk about seems like it's only to the benefit of the plaintiffs, which is actually not true. It's really to the benefit of kind of many times the defendant. They may initially sort of push back at class certification stage, but ultimately, if you have a class action, it works well for the plaintiffs because, and the entire system. The plaintiffs, there's strength in numbers, and so they work collectively. They're able to bring claims. If they have small claims or they don't have a lot of resources, they can come together. But it's also good for the civil justice system because now you don't have the inefficiency of one case after the next case after the next case, all these individual cases that really share a common bond. They're all challenging the same alleged discriminatory policy. They all have the same collective goal. It makes sense to the judges that are totally swamped, the federal judges in terms of their dockets, and the parties not to litigate each individual case over and over again, but in fact, to do this as one collective action. We resolve this once and for all to the extent that we have these things in common. Now, that's also good for the defendant. The defendant may choose to settle a class action or it may get litigated, but often it will settle. And that's because they can, within one case, resolve all of these issues that are in common. So it's actually to the benefit of the defendant often to have this resolved as a class action so that they're not stuck with each of these individual 1.5 million women, bringing up the same issue over and over again. So it's definitely, I think it's helpful actually to all the parties to keep the class action mechanism alive and well. And I do think the court looks at, is this fair to the defendant? There are many, there are lots of components to the rule that are looking out not only for the class members, but for the defendant. That's why it's a difficult standard to meet. That's why you have to meet all of the criteria of Rule 23A and one of them of Rule 23B. I think the issue here is let's not make it so hard that we now shut down the ability for people to collectively have their civil rights enforced and move forward.
If I might just add one other quick point that I think we haven't actually underscored so far, is that much of this balancing and the weighing of the experts and whether at the end of the day there was a credible enough case made by the plaintiffs about the commonality of the issues in such a big employer was made by the district court. And district courts are assigned to find the facts. And yes, there is a question about what's the legal principle that ultimately the Supreme Court will decide. But one concern is that the Supreme Court, it's not the role of the Supreme Court to be deciding after the district court already looked at the experts and already looked at Wal-Mart's experts and the plaintiff's experts and chose to credit the plaintiff's experts in this case about the common practices and the effect commonality, that those factual findings were taken and given respect by the Court of Appeals and are supposed to form the underpinning for the Supreme Court as well. So the balancing about how unfair this might be to the defendant versus how fair this might be to the plaintiffs, how much are these issues ultimately common issues versus very discrete differences that are unrelated, region to region, manager to manager. Those are the kinds of things that we actually have a quite extensive factual record on. And that is a record that is supposed to be the basis upon which the ultimate applicability of those legal principles will apply. So the Supreme Court is not supposed to be trying to figure out the facts as if the district court hadn't already, through a very extensive proceeding, decided them, having heard them, listened to the experts, and evaluated and weighed them.
If I might just add my half cent on the question that you raised, because I think it's an important one that's gotten lost a little bit in the case, too. Wal-Mart often makes it sound like they want to defend all these cases individually, but they do not prefer 500,000 individual cases to a class action. There's also been a lot of emphasis in the briefs on how class actions settle, and that's true, although most cases settle, class actions not. But the other part that has not been told is that when class actions are decertified, they don't turn into individual cases, they go away. And that's what Wal-Mart's hoping for in that.
Hi, Caroline Frederickson with ACS. I just, and Adam sort of brought this up, and I'm not sure how relevant it is to the ultimate disposition of the case by the Supreme Court, but, and this relates to what Heidi had to say about the turnover at Wal-Mart. I think Andrew had said something about the way that the class itself is made up of current employees and past employees, former employees. I guess I would suspect that composition of that class has changed a lot, and it's certainly to Wal-Mart's benefit to stretch this case out as long as it can so that there are more and more in the former class and the issues of commonality become harder to make. And I'm just wondering how relevant is that to this discussion? Will the court look at that? Anyway, it seems to me to be an important point that hasn't been brought out entirely, and I'm wondering if you could expand on it a little bit.
Yeah, I'm happy to. This is an interesting question. The circuit courts have struggled with what is the central interest in the case. What is it that the plaintiffs are trying to achieve? And oftentimes, in the Second and Ninth Circuit, it's the focus rather is what the plaintiffs actually say in their complaint, which is to primarily obtain equitable and injunctive relief. So the subjective interests of the plaintiffs in the Second Circuit, the Ninth Circuit came out with a slightly different iteration, but the same basic concept. What is the main thrust of the case? When you have a very substantial number of former employees comprise the class, that interest erodes. That argument is undermined. Let's just say, hypothetically had an entire class of former employees. That's the entire case. Well, for them to argue that the main objective is to eradicate, to fix the policies and practices that cause discrimination, I think that's still a plausible argument, but you can understand how that would be undermined. And I go back to the earlier point. A lot of what Wal-Mart has done is both strategic and tactical in terms of defending this case in litigation, and that's one example where they can now argue more forcefully that the percentage of former employees has risen to a point where plaintiff's statement that the primary objective of litigation is to eradicate discrimination, is to obtain injunctive and equitable relief, becomes substantially undermined. I mean, at least that's a talking point that they can make.
Could I just make one other very, very quick point about that? And that is, it's an axiom that the ultimate strategy of a defendant is to just string the case out as long as possible, hoping that the plaintiffs will run out of money, run out of time, run out of interest, run out of connection to the ultimate matter. And the point of a class action is to be sure that when the plaintiffs are appropriately raising an issue that affects the broad class, that those class interests are actually taken into account and protected. So there may be a shift because of the passage of 10 years, whereas when it started, the original plaintiffs were all at Wal-Mart, and over time, fewer and fewer of them are. But the class is ultimately going to be protected by those who remain. And that's where I want to go back to the injunctive relief and being so important going forward. And go back again to Lilly Ledbetter. She brought the case on her own near the very end of her employment history. And when she ultimately lost, she got nothing. Had that been a class action, maybe not only would she have gotten some of the back pay that she was entitled to, but other women at Goodyear whose interests she was never certified to represent would have had their discrimination remedied too. And in her instance, the jury was so taken aback by the extremity of the discrimination that she described and that they found existed, that they actually did impose punitive damages against Goodyear. So a class representative is certainly doing it on behalf of their own interests, for sure. But the whole point of the class action is to protect the members of the class and those going forward who will be at Wal-Mart. And when you balance out the back pay at issue in this case as compared to what the ultimate value is for all those women going forward into the future at Wal-Mart, the class action in future interest dwarfs the amount of back pay that's at issue in Wal-Mart right now, even though it seems like such a big number to us.
I think we have time for one more question, and you've been patient.
I'm Cynthia Butler. I'm a plaintiff's attorney. I've tried to certify a class action that went to the Third Circuit, and what ended up happening was it became multi-plaintiff instead afterwards. But my question is, obviously, for any institutional change, this is the ideal mechanism, because for discovery purposes, you get met with all kind of overbroad objections. And I'm wondering if anybody's ever done sort of statistical survey about how many motions to compel overcome that, because the individual credibility battle that happens with any one particular person never, ever even allows you to gather the evidence sufficient to form the argument, to do the statistical analysis, to create the institutional progress. So if you're talking about addressing an institutional reform in, corporate-wide. Obviously, this is the ideal mechanism, and you have to preserve it. My question is, do you have an ability to bifurcate the various class members into different types of class sizes, depending on whether they're more suitable to B2 or B3 at this stage? Can the Supreme Court bifurcate and preserve one side, the current employees, for example, where the institutional issues do predominate over, the people who don't work there anymore, perhaps? Not to concede that argument, but I'm just wondering if bifurcation's an option.
Well, it's the Supreme Court. They can do almost anything. But Rule 23 does not prohibit an appellate court from redefining a class to a more certifiable class. Appellate courts do it all the time when there are appeals under Rule 23F. And so there's nothing, I think, that would prohibit the Supreme Court here from saying, as defined, this is a problem, but if we carve off this bit and redefine this bit slightly, you have a class that's certifiable. Or to just decertify this particular class, but send it down with certain instructions on remand. I think that's well within the Supreme Court's power to do. Adam may have a different.
No, I agree with that. It reminds me of the game of life. Everyone winds up at the retirement slot. So there are lots of different paths to get there, but if there's certainly any number of manageability options, including certification as an issues class, and it'd be under C4, which the Ninth Circuit did, but didn't sort of lay out explicitly. There are plenty of tools. Remember, too, that Rule 23 is a management tool to permit the court to efficiently hear a case. That's the construct. It isn't to give an advantage to one side or the other. So there are plenty of management tools that are built into Rule 23, and more broadly, courts are allowed to, hear cases and manage cases in the way they see fit. So there are plenty of solutions to the problems that are presented in this case.
Yeah, I think that goes to this question that's going to be before the court in terms of which test do they ultimately decide to use when they're figuring out do monetary damages predominate over the rest of the case or the injunctive or declaratory relief. That it's important to keep that discretion, to give courts discretion to make those decisions. That there are tons of options that are available, and a number of courts have sort of crafted class actions in different ways, only because they have the discretion to do so. And so you have to be careful. Some of the courts of appeals, depending on the approach that they have used, how they decide to define predominance, some of them are more narrow than others, and if they go with a narrow, bright line test, then it really cuts off the ability for judges to exercise discretion and make sure that they, in fact, can be responsive to each case that comes before it. So that's going to be an important thing to watch out for in this case.
I do want to go back to a comment, Suzanne, that you made about the fact that B2 classes were designed for civil rights statutes very much in mind to deal with the broad, ultimately recognizable class nature of discrimination. And in the idea of courts can fashion a lot of things in order to make them practical, the point of a class action in a civil rights case in particular, and using the B2 class in specific, was to facilitate dealing with that systemic change. That is what Title VII framers in Congress had in mind, and that is what the Rule 23B, one of its major purposes, was to begin with. So in deciding this case, it's not as if the Supreme Court is without obligation to look at what the intent was of Rule 23B and Rule 23B2 in particular, and Rule 23A, because Wal-Mart says there shouldn't be able to be any class action at all here, let's not forget. But in a civil rights case in particular, when we are dealing with the nature of discrimination, if somebody is being discriminated against on the basis of race or sex, for example, that's a characteristic that can go more broadly than just they themselves, obviously. It's all the more important to think about why the framers of B2 and its intersection with Title VII would intend that this commonality and systemic approach was the point of why the law was structured the way it was. And that, I think, is ultimately part of what makes this case so important, whether that intent and purpose of the law is going to be realized by the Supreme Court and respected by the Supreme Court in its decision.
And that we will know soon enough. The case will be argued on Tuesday. If you're planning to go and don't have a seat, you want to get there early. And I understand the weather for sleeping outside is going to be pretty good. This is going to be a very, this is an incredibly important, and as you can tell, very difficult case. I know there's a lot of different routes the Supreme Court might take in that, but hopefully the panel today has provided you with more insight to all the complexities and the importance of the case. I want to thank you all for coming and thank the panelists as well.